We are here, and we are going to talk about tenant appeals for evictions. And for those of you who were able to get, oh, great, I'm glad. Hello, James. I see McNary Realty Group says it's all good, and I'm happy to hear that. So today's topic is my tenant appealed their eviction, and I don't know what to do. I'm going to give you some tips on dealing with that exact thing today. And I want to make sure that for those of you who show up regularly on this, you know that you can always ask questions through the chat. For any of you who are new to this process, I welcome questions. We gather some questions. I've got some preset questions here that I'm going to go over in just a bit. But we also welcome questions during the live stream. If you have one for me, I'm happy to answer it to the best of my ability. However, if you can get your question in, I'll read it and prepare a response for it to present to the group. But let's go ahead and get started. So, if you are in the middle of an eviction appeal, sometimes, people freak out the moment they see that their tenant has appealed the eviction. But it's really not that big of a problem. It might be unfamiliar, that's for sure. But I want to give you some tips for you to consider before you really, to feel like maybe this is beyond, your capability. I assure you, you're going to be fine. If you were able to present a successful case in the lower court, you can probably do it again in the next court, except for a few of the formalities. And so I want to talk to you about those. So the first thing to consider if your tenant has filed an eviction appeal is there a bond that's required, or is there some amount of rent that's owed into the court registry in order for the tenant to proceed with their eviction appeal? You may find that because they've appealed, they got to put some money in the till, and that part of the appeal arrangement is that they pay some amount of money. Now, this isn't always clear at the time of judgment, and I know sometimes people walk into the court, they hear that they won, but they didn't really understand all the pronouncements from the court, or maybe the judge just wasn't very explicit on what is required of the tenant in the event of an appeal. And perhaps it's only ever explained in some written format that you haven't received yet, or you didn't even know to review. So always, 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 if your tenant has filed an appeal, reach out to the court, see if there is any requirement for the tenant to pay any amount of money in order to proceed with possession during the eviction appeal. Because the next point is, well, what happens if the tenant doesn't actually comply with this requirement? The reason you want to know if it's required of them is their failure to pay could mean that you get possession back sooner rather than later. And so often when clients come to me, we check in at this step, and occasionally we see that the tenant failed to make a payment. And so in Texas, if a tenant files an eviction appeal and agrees to pay rent into the court registry and doesn't do it, we can request an immediate writ of possession from the justice court, or if the case has already traveled to the county court, we can request a hearing from the county court to get immediate possession and just help out the client a ton, because you've been able to collect possession without the need for a second trial, usually weeks in advance of where they could have gotten possession had they not sought our help. And so it's important to know these deadlines. Does your tenant have a requirement to pay into the registry as part of their eviction appeal? Second, what happens when they don't? And so by knowing these rules, you're better able to position yourself to recover your property faster. Third point, your tenant has appealed. Has the case been set for trial, or do you need to set it? In Harris County, where my office is based, eviction appeals are set automatically by the court, but that's not true in every county. We know that next door in Fort Bend County, we have to request that hearing. And if you're twiddling your thumbs and waiting for the court to act because you're used to things in a different county, you can have an excessive delay, and you certainly don't want that. So the first available date that the court can hear your case, if you're required to make that request, I would do it day one. make that request for the earliest available setting and make sure that you are on the court's docket. It doesn't hurt for you to reach out to the court and ask, do I need to set this or does the court set this? And if they tell you, no, you'll get a notice in the mail, we will set it and give you notice. Well, great. But if it's on you, you want to know that that's even a thing. And so you want to reach out to the court and make sure if your tenant has filed an eviction appeal and you are required to set it, that you contact the court the first chance you get and ask for the earliest available trial setting so you can recover possession quickly. So the first thing was, does my tenant owe rent into the registry or some kind of bond into the registry? Second is, what happens if they don't pay it? Third, do I have to set trial? The fourth thing you have to consider is, what does the court require in terms of submitting evidence? So sometimes people show up to trial thinking that they can do it just like they did in the justice court, but the trial court on appeal has very specific requirements. Your court, for example, might require that you file through electronic means all of your evidence up front. And they don't take anything the day of trial. If you didn't e-file your evidence, you don't get to present your case. And guess what? You're going to get reset at least a couple of weeks, maybe a month, and that's more lost time and money. So before you ever show up to the trial, make sure you're familiar with those rules so that you don't show up unaware and then having to deal with a setback of a couple of weeks or up to a whole month lost just because you didn't know what you had to file to be prepared for court. Fernando writes, had one who appealed with the help of Texas legal aid, that happens, just to stay as long as they could, then never showed up to the county trial and ended there. And unfortunately, that's a common thing where a tenant will appeal not because they've got a legitimate argument to make or some legitimate claim that, hey, they actually paid the rent, or that you did something wrong procedurally. It's really just a means to extend, just how much time they get to stay there. And if that happens, you want to find mechanisms in the law to recover the property quickly from people who are just trying to delay. James writes, I issued a 3-day notice to vacate for unpaid rent for July and August. If the tenant pays both months, can I still proceed with eviction? I use a TAA lease. Can you proceed? Maybe. Now, you're saying if the tenant pays both months. So that also depends on what your communication is with the tenant. If you and the tenant are trying to make a deal and you express to the tenant, even impliedly, that their payment of the rent means you're going to forego your eviction, well, of course you won't be able to proceed to trial and evict the tenant on those statements, which is one reason why I don't recommend dealing with a tenant purely through some kind of oral mechanism. Everything is in writing, and if in writing you express to them, look, I'll accept the rent and lower the amount that I seek in the judgment, but you must vacate. I will continue to seek possession. So that's probably going to change the rules, and they may not be so eager to pay if they know they're going to get evicted anyway. But as long as it's clear and both sides clearly understand that even by accepting payment, I'm still demanding possession, you're likelier to get an eviction judgment. But the moment that a judge hears, wait a minute, you guys were trying to work things out, he paid you for 2 months and you still want to evict, but he's saying he thought you were going to withdraw this eviction, that's where things go down the toilet. And courts are very unlikely to, unless there's something in writing that explains what, in black and white very clearly, that's not really something I would recommend, James. If your overall goal is to collect money, then take the money. If your overall goal is to collect possession, forego the money and see if maybe you can work something else out. Yeah, if you want to evict for other issues, I would just reject payment. You could, however, enter into a Rule 11 agreement. This is a common thing that we do. A Rule 11 agreement is some agreement that gets filed with the court. And you might say, for example, look, if you pay X, I'll let you stay until, maybe an extra 2 weeks, that sort of thing. But again, unless you can work something out that's rock solid and the court is going to approve, that's generally not something that I'm going to advocate. So a little something there from the chat. So the 4 points I've covered so far. If your tenant has filed an appeal to your eviction, you're going to want to know whether they owe any amount of money in a bond or in rent into the court's registry. In Texas, this is a common procedure, and it's an issue throughout the states. It's going to vary as to what the mechanism is or what it's called, but your tenant might have a requirement to pay something into the court's registry. Second is, what happens if they don't? In Texas, if they are required to pay rent in the court's registry while the matter is on appeal and they fail to, you get the option to go and pursue a writ of possession. This can get property back in your hands faster than waiting for the appeal trial, which could be 1 or 2 months in the future. The third thing to think about is the trial for the appeal set automatically, or do you have to request it from the court? In many instances, the plaintiff has to request the first available date, and the court gives them that date and then sets the matter for trial. Make sure you know whether your court requires that. The fourth is, how does the court want you to turn in all your exhibits and your evidence for trial? You might have to e-file it. You might have to mail something in. The court may require that you share a copy of your lease, of your rent ledger, of your notice to vacate with the other side before the day of trial so that they can properly prepare. If you have such a requirement, you need to know before the trial date. Get ahead of it, call the court and find out. And the last thing that I recommend whenever a tenant has filed an eviction appeal is, when do you know you need to hire legal counsel? Now, in Texas, there is a rule that certain entities, like an LLC or a corporation that own property, can send property managers or can send agents. But in other cases, an agent or even a property manager cannot represent an LLC or a corporation or a limited partnership. If you have an entity, there's a chance that, and a pretty good chance, that you might have to hire counsel. In fact, we get phone calls all the time of people who get turned around at the courthouse and told, listen, you can't proceed with your eviction because of the way your eviction was filed, or because of particular facts in your case, or because the rule simply doesn't allow it. In your state or jurisdiction, you may be required to hire counsel, and you're going to want to know again ahead of time so that you show up ready the first setting, so you're not delayed 2 weeks, 3 weeks, 4 weeks for something that you could have prepared for, weeks before, so that you could recover your property sooner rather than later. Listen, if you figured it out and how to do a successful eviction in the original court, an appeal is not that different, but there are differences you need to know about. If you need help, of course, you're going to want to contact a landlord attorney who can supply that help, maybe even representation. But sometimes it's good to just give us a call. We'll set up a consultation just to kind of give you a few pointers so that you can present your case to the best of your ability within the rules of the county where your case is located. I hope this is helpful. We're now going to move on and get to your questions. So for those of you who are able to supply questions to us, we gather questions from a number of sources. We have a weekly newsletter. If you're not on our newsletter and would like to, send us a message through the chat and we'll add you. All we need is your email address. If you are a member of Texas Landlords, our Facebook group, we also collect questions from clients. We collect questions from members there that we read here and answer. But if you're in neither of those positions, I welcome you to join them. But you're here live. Ask your question live, and I'll be happy to answer. Here we have Alexander Valentin. Question for the attorney. How often do tenants in Texas appeal an eviction, and what is the typical timeline a landlord should expect in this situation? That's an excellent question. If the tenant appeals, will they have an attorney? I'll get to that one next. So the timeline that we explained in Texas is pretty simple. We tend to approximate that about 20% of evictions will get appealed. Now, some of them actually make it to a full trial, but not all of them by far. The majority of eviction appeals are also defaults, and the tenant leaves because they really just need a few extra weeks. A couple of extra weeks is all they needed. They pack up, they leave. And in many cases, the landlord's like, I don't even care about the eviction appeal. I got my property back, and that's what matters, they let the case dismiss on appeal. However, it's important to know that if you do that, the original justice in Texas, the original justice court judgment is gone. And unless you follow it downtown, unless you follow it to the county court in the state of Texas, an appealed eviction is erased, and you got to win the second round in order for that eviction to stick. But again, in many cases, the landlord simply forego the eviction appeal trial and are confident that getting their property back is the better move. So about 20%, 1 out of 5 do get appealed. And of those, really very few of those are hotly contested. There's a few where the tenant's really going to fight, and that's when it might help to have, particularly to have legal representation. But it's about 1 in 5 get appealed. Now, how many of them show up with attorneys? Very, very few. In certain cases, yes, there is legal aid assistance available in certain counties. If your tenant meets certain financial, limitations, then yeah, they might be eligible for this kind of assistance. It's not available to everyone, but if they are eligible, yeah, you could be in a fight with an attorney who's going to look and who knows how to dig through cases to defeat your claim if you have errors. So one of the things that we offer to clients is we'll review your petition to make sure you don't have any of these landmines waiting to blow up on you and cause you to start the whole thing over. In terms of a time frame, we usually tell landlords you can expect anywhere from 30 to 60 days of additional time after you've won in the justice court and your tenant has appealed their eviction. That appeal trial comes about 30 to 60 days before you're probably going to get your property back. And so these are estimations. Occasionally it's a little faster, but usually about 30 to 60 days. Hi, Ernie. If a tenant is not happy, this is A. If a tenant is not happy with the itemized list of deductions after moving out, how long do they have to dispute the charges? So in Texas and in most states, a breach of contract claim, you get 4 years. Most cases don't wait that long. In most cases, the tenant is going to file that lawsuit within the first year, but they have up to 4. And so the law allows them this extended time. Whether they're going to take that full amount of time or not is really up to them, but it is plausible that within 4 years, you could still be sued. Hopefully that's not the case, but if it is, you're going to want to preserve all of your records for at least 4 years. I would recommend 4.5, because what you don't want, and I've seen this happen, you don't want for someone to sue in the last month or that last week of the 4-year statute of limitations, and it takes 30 or 40 or 60 days for service of process before you even know about it. And now you're scrambling because I threw those records away a long time ago. That's not something that I recommend. Keep all your stuff for at least 4.5 years before you get rid of them because of the potential for a lawsuit. Alexander writes, once an appeal happens, should the landlord expect to lose 2 to 3 months of time? Am I right? Yes and no. So if your tenant has a requirement to pay money into the court's registry, you may lose time, but you may not lose money. And so one of the good things about the rules in Texas, if you know how to enforce them, is that while the tenant is on appeal, they're required to pay rent, generally speaking, into the court's registry. And if they don't, you can go and get an immediate writ of possession. They call it an immediate writ, but nothing in state government is immediate. But it does speed up the process considerably. And so theoretically, you could lose up to a couple of months, maybe 3 months in certain circumstances, but generally speaking, 30 to 60 days. And you may not lose money if the tenant has actually paid into the registry. Let's see, Hind Washington writes, following up on Ohm's question, are we required to provide receipts to support the items charged back to the tenant? Maybe. Your initial itemized list in the state of Texas does not require you to send receipts or photographs or invoices. or estimates that you got. None of this stuff is required in the itemized list. The only thing required is that you get it to them within 30 days and that you break down the costs for each valid deduction. Now, where receipts might come in is when the fight brews. If they say, wait a minute, wait a minute, wait a minute. I understand 1 through 3, but 4, 5, and 6, no way. There's no way it costs that much, or there's no way I caused that damage. Or if I did cause that damage, it was normal use and ordinary wear and tear. At that point, you might be incentivized to send over the evidence that you have and say, nope, there's no way that any of that's true. Here, for example, is a copy of the picture of, for example, the kitchen cabinets before you took possession. This was June 1st of last year. Here's a picture of the cabinets after you left. You caused damage in excess of ordinary use and beyond normal wear and tear. Cabinet doors should not have holes. You scrape the paint off. One of the doors is missing. Clearly, you caused this damage, and the evidence can prove that. So, no, you're not required to show it up front, but you might be incentivized to share it if they start to contest your notice. Hein continues, I provide a pricing list to the tenants at the time the lease signing that shows what I would charge for damages. Am I covered there, or do I still have to provide receipts? Well, I don't know what you mean by covered, but speculative harm is not the same as actual harm. Speculative costs, not the same. Estimates are not the same as costs. And so as a proof issue, the court is more interested in the actual value of the harm as closely as you can prove it. And now I'm not going to get into an evidentiary lecture here, but if it cost you $1,200 to fix those cabinets, as opposed to, Your Honor, I was damaged, the value that I lost is $1,200, that's less precise. And so if you can show what you paid out of pocket to fix the problem, that's going to be more convincing than I think it could cost up to $1,200. Again, stronger evidence is always out-of-pocket cost. Okay, so here we go. Vanessa McGill writes this question from our newsletter. Ernie, can you please explain the new law that is going to affect regarding evictions? I keep hearing about it, but no one really tells me anything, and I can't find information somewhere on my own. I am going to make a full-blown video on the changes to the property code that are coming in January of next year. That's coming out this fall. I promise you I will touch on each of these. Essentially, there are changes to notice provisions. In certain circumstances, you will be able to send a notice to vacate through email. Again, I'm going to go in depth in that video. Additionally, there are changes that affect squatters and the rights that landlords have to expedite issues that have to do with squatters. Again, I'm going to go more in depth defining what the terms are and what the procedures would be. And so for every other change that affects landlord-tenant issues, again, keep a lookout. I will produce a video this fall with all the changes that are coming in January of 2026. The question goes on, however, can you please give tips or tell me where to find the information regarding evictions and what does the attorney look for in order to get it thrown out? We had questions about this earlier with regard to legal aid attorneys. So I like where this is going. I run into attorneys in the lobby asking tenants if they have an attorney. Their services are free. They then come in to the court and look for loopholes and make things harder. Example, they'll argue if the notice to vacate is wrong. They argue that the owner-landlord certificate with the state is not up to date. These are just some of the things I've noticed. I actually feel sorry for the owners because these tenants are showing up and arguing about a home that does not belong to them. These are just some of the ideas I know you'll be able to touch. You will not be able to touch on all, but this info is much appreciated. So Vanessa, I want to answer your question in a couple of ways. Number one, yes, there are tons of resources on how to get these small procedural things correct. I offer numerous videos absolutely for free on my channel having to do with notice, prepping for trial, how to file your eviction, how to handle appeals, lots and lots of stuff that I've made over the last 5 years on this channel about these topics. I also want to announce that on Friday, August 29th, which is coming up, we're actually going to host a live event where we are going to workshop the most common, most important notices that landlords send, including notices of termination or non-renewal, notices to vacate, and notices of default. Not only am I going to show you how I word these and what I recommend to landlords, I'm going to give you these notices if you attend this workshop. I'm going to walk you through how to use them, and then you're going to be able to use them over and over and over again, along with my written instructions that you'll walk away with, because I want landlords to get these notices right. If you are interested, there is a link in the description below. If you're interested, again, this is a paid event, but I'm going to walk you through all these things. If you're looking for resources specific to notice, this is going to be a great way for you to find out how to nail your notices every single time. If you're asking me now for kind of quick tips, talk to people. If you're not talking to an attorney, which you're not required to talk to an attorney, but talk to people who've done the notice correct over and over and over again. Someone who's gone to 100 evictions, they're going to have some good advice on notices. Some realtors have access to forms in Texas. The Texas Realtors forms are quite good. They're kind of fill in the blank, and they don't come with tutorials, but a good realtor is going to know the kinds of things that should go in a good notice. Of course, you know, we're pros at this. We do this all the time. And so if you just need a little nudge, a little help, you know, this kind of thing might be perfect for you. You definitely want to know, one of the main tips that we give is the delivery of the notice is so hard to prove sometimes, unless you're sending your notices through the U.S. mail. We send all of ours through regular and certified mail, and every single time showing proof of that delivery, showing the tracking helps to establish that it was delivered. It doesn't matter that the tenant didn't open the mail. It doesn't matter that they willfully avoided ever looking at it. The fact that you sent it is what matters the most. That's what keeps you in compliance with the law. And it's one of the things that one of these legal aid attorneys is going to look for. How did you deliver it? Because if you say, well, I gave it to someone, or I attached it to the outside of the door, those get shot down so easily. If you just gave it to someone, but you don't know who it was, and especially if you gave it to a kid, the law requires in Texas that the notice be given to an occupant 16 years of age or older. And they say, look, all my kids are under 12 years old. So if you gave it to any one of my kids, you didn't follow the rule, your notice gets kicked out. So you're going to want to know what the law requires. If you need a thorough, in-depth workshop, again, we're offering that at the end of this month, Friday the 29th. More information in the links in the description. Okay, I got some catching up to do. James writes, I wonder what a fair hourly rate to charge for your time. Now, if you're asking about my time, I can definitely disclose that. But I think you might be asking about your time. And that's really going to depend on the skills that you have for the work that you provide on the property. You know, if you're charging $30 an hour for your work, it should be because you do $30 an hour quality work for the thing you're doing. I don't know that you could charge $50 an hour to pick up trash, but you might be able to charge $40 an hour to repaint a room, or to I don't know, maintenance a toilet, maybe even more actually. And it really depends on the skills that are required. And the way I tell landlords is, if you were doing this professionally for somebody else, what would you charge? It's going to come down to what is reasonable for the task at hand. Next, Alexander Valentin writes, thank you for your input. This may be a routine situation for an attorney, but for the landlord, it's very stressful. Do you help guide landlords through the process to make them feel more comfortable? Yes, actually we do. Again, the resources that we have here for free. I also have a paid eviction course. If you're interested in that, you can go to my website, check that out. But in terms of notices, Again, that workshop is going to be invaluable for you if you can make it. I don't know how many of you are in the Houston area, but if you can make it, that might be really helpful. Again, that's August 29th. Vanessa, okay, thank you. You're welcome, Vanessa. I'm glad you were here to hear my response. Ohm adds, thank you, Ernie. If a tenant is unhappy about losing their entire security deposit due to damages exceeding the deposit amount, do you recommend pursuing legal action against them or being passive? That's going to depend on two factors, and I talk about this often when going after tenants who owe money. Number one, can you locate them? If you can, then you can sue them. If you can't find them, you can't sue them. That's basic. Number two, if you did successfully sue them, could you collect? Not might you collect, could you collect from their assets or from their accounts? And if you simply don't see them having sufficient assets or accounts to pay, then it's not worth getting that judgment. And so if you're saying, well, I've got $5,000 worth of damage, but there's no way I could squeeze $5,000 out of this guy, not worth it. Take it as an expensive lesson, but again, don't throw good money in after bad. I just don't recommend it. And that's me saying I'm turning down work that you want done because I'm advising you it's just not a good use of your time and money. So I don't ever recommend those. But if they have assets and you know they have the capacity to pay, absolutely go after them. Hein Washington, thank you. You're very welcome. Says, and does it help removing that 4 years time frame from the table from their side? I love the idea of the workshop. So I'm glad you do. I'm not sure what you mean by removing the 4-year time frame. That's set up by statute. So that's not part of your agreement. So you couldn't just say, oh, by the way, if you're going to sue, you have to sue within 6 months. That would not be an enforceable term in an agreement. James writes, sometimes I have refunded the full deposit just to avoid any unpleasant issues. My mental health is worth it to me. And that might be the case. I talk to landlords about this on a weekly basis. And I illustrate it with highlighters. And I lost my yellow highlighter, but I want you to presume this is a yellow highlighter. I've got a green one and I've got a red one. I don't know if it's clearly showing up on the camera here. But whenever I look through deposit deductions, I say, look, a solid green one means absolutely go charge it up. You're entitled to every penny. A red one means nope, you never had a claim. You can't charge them to replace the roof. They didn't cause that. That was hail damage. That's a never, you can't get away. Or that's clearly ordinary use, or that's clearly normal wear and tear. That carpet's 12 years old. You're not getting any money for that. That's normal wear and tear. You're not getting it. The ones in the middle, the yellow ones, those are the ones that get us in trouble. Because if this makes up a substantial part of our deductions, we run a risk. These are jump balls. These are 50-50 shots. Because maybe we can convince the court that they're fully responsible, or maybe we can't. And when it's hard to determine, when it's not a slam dunk, absolutely, definitely, we got you dead to rights. These are the ones that get you in trouble, and they may not be worth the headache. So I hope that's it's a helpful illustration for you in determining. Now, if you can't decipher which is which, that's when you come talk to somebody, and I will lay it out and let you know what courts have said about deductions on your list and whether I would recommend keeping them or limiting them, and what I might recommend in terms of a refund, if any. Now, certainly if you have enough green to cover the deposit, then you're good. I wouldn't worry about the yellow, but you must have enough valid deductions to exceed the deposit before I'm ever going to say, yeah, take a risk with the yellow ones or the so-so ones. Because you've got enough here. One easy one is, they didn't pay the last month of rent. And if they have 1 month of rent on deposit, then that's always an easy one because, that's going to wipe it right out. But when it's less specific or less precise, you run a risk. Okay, let's see. We got more here. Fernando writes, don't make a notice and argument. Less is more. I agree. You want your notice to be precise. You want it to be unequivocal. You don't want to just say get out, but you want that to be the point. They have to leave. Vanessa says yes. James says yes. Sherry says, shalom, Ernie. Shalom. Let's see. Ashley Holloway says, I did submit this question via email, but not sure if you will get it. And we do have a cutoff. Generally speaking, noon is the cutoff. If it came afternoon, I'll pick it up here, though. Tenant let her non-running vehicle in our garage. Oh, yeah. Actually, I do have that. That's my last question. It did make the cut. I'm going to save it for the very end. She has moved out. Okay, yes. Again, Ashley, I'm going to get to you in just a bit. Let's go to the next question. Sankop Coley writes, I bought a property in 2021 and the house has been rented ever since. Now I receive an HOA violation that the HOA has a leasing restriction of not more than 10% rentals in the community, and it was mentioned on the resale certificate, but not mentioned anywhere else. Can I fight with the HOA that this was not communicated properly? Maybe. That depends on what you mean. So if the bylaws are, part of the court, part of the county records, and that's in the bylaws, no. You have constructive notice of anything that's out there registered with the property clerk's records. However, if this is something new, then the question is, did they announce it at an HOA meeting? That's a maybe. I would argue, though, how can they prove you're not part of that 10%? And so that's something I might investigate. And I would go and attend a meeting. There may be in the bylaws a mechanism for you challenging this kind of thing. I would pursue that. As far as fighting with the HOA, I would, send a demand letter, ask for this information, ask where it's posted, ask them if this even is featured in the bylaws, and if so, in what section. And so you may find that it was properly noted somewhere, and that you happen to be subject to that restriction. If they can demonstrate that, then I would say it's not worth the fight. Okay. Teresa from our newsletter asked, while the tenant is still in legal possession, what legal steps can an owner take to bar a specific individual from being on the property? Can the owner obtain a criminal trespass order before the eviction is complete? Do we need to get, we need to get the boyfriend legally banned now? What process, police, court order, written note will hold up in court? The son is mentally disabled and has caused utility abuse, harassment to other tenants, disrupted the peaceful enjoyment of the property for the owners who also live on site along with other tenants. This is a triplex. Okay, so bad news is it's hard to claim that this individual is a trespasser if they are allowed to be there under the terms of the lease. I don't know what your lease says in terms of guests, but if this individual has caused criminal mischief of some sort and you have a particularized threat against you from this individual, then maybe you can get a restraining order that prevents him from coming. This really is more of a criminal law question because the eviction court doesn't allow you to prohibit the tenant or their guests until after a writ of possession has been executed. Up until that point, you simply don't have the mechanism to keep people away from the property, unless, of course, there is some criminal violation. And the criminal law allows you to do this. I don't know of any. The things you've described might rise to the level of some criminal complaint, but that's something you'll have to talk to the local authorities in your area for them to give you a better response, because I'm just not familiar with any criminal laws that might apply in this situation. 8 Cinco writes, tenant has appealed the eviction. She's saying she's sick and that I don't fix anything, which she never asked till now, that the eviction was served. She has not paid rent since July and repairs were fixed before the court date, July and August non-rent payment. So for these guys, and this comes up a lot, I guarantee you, every time you go to the eviction court, you're going to have someone say, oh, and they didn't fix this, and they didn't fix that, and they didn't fix this. In Texas, The failure to complete a repair is not a substitute, is not allowance to withhold a rent payment. It just does not justify withholding rent. There are mechanisms where a tenant in Texas could pay to repair the thing themselves and subtract that amount from the rent, showing the receipt to the landlord. But they got to follow some major steps to accomplish that. And most of the time, they simply do not follow the steps that are required under Chapter 92 of the Property Code. So if she hasn't done that, then there's maybe a provision in your lease that says something to the following effect. Look, I don't have to do repairs if you're not current on the rent. Now, that's a strong statement. And what I would say is if repair requests are made that materially affect health and safety, you're going to want to get those done even if rent goes unpaid, because you don't want a court to look sympathetically on someone who's dealing with, a pretty bad issue in their unit. Go get that taken care of. But as far as it being a justification to withhold rent, it just isn't in the state of Texas. It's not a legal defense. There is a repair and remedy claim that they could make, but again, they got to follow the steps. They got to follow those rules and then file those claims. If they don't do it, then no, that doesn't usually serve as a good defense. So Kalisha Reed from our newsletter writes, what is the proper requirement for sending notices to vacate? Do we have to send a notice via regular mail, certified mail, affix it to the front door? We recently had a case dismissed because we didn't have an address on the envelope affixed to the door, and the notice sent via regular mail and certified mail only gave the tenant 3 days to vacate. Please advise. This is another case, Ms. Reed, where I'm going to say, guess what's happening at the end of August? August 29th, we're holding a workshop in the Houston area. For those of you who are interested, there's a link in the description where I'm going to workshop exactly how to get your notice to vacate right, exactly what we recommend when delivering it. Because one of the things that you mentioned here is that the notice by regular and certified mail only gave 3 days to vacate. Well, did you know that if you receive federal funding or if you have a federally backed loan, the law requires a 30-day notice? Well, you might have been shocked to find that out, but it is a rule. And there are free videos on this website, on this channel, that talk about that very thing. When is a 30-day notice required? If you receive federal funding, Section 8 housing, for example, if you have a federally backed mortgage, Fannie Mae, Freddie Mac, then you're required to give a 30-day notice. And if you don't know that, you could be surprised at trial by that claim by your tenant, and that gets your eviction kicked out. And certainly if you don't follow all of the rules for posting on the outside of the door, that also gets that notice kicked out. And so you want to make sure that you've always sent notice in a proper manner. One thing that trips up people all the time is, let's say they're sending their notice on September 1st, and they say, well, you better be out by September 4th. And they send it through regular and certified mail. But the tenant shows up and the envelope is stamped September 3rd, which means the post office processed it on the 3rd, and they testify, I didn't even get this till the 5th, but they wanted me out by the 4th. There was no way for me to comply. I strongly discourage landlords from putting an end date on their notices to vacate, because if you're delivering it by mail, that could happen. And now you've got a court saying you've got an invalid notice. There's no way they could have complied with it. It's mathematically impossible. Start over. Instead, if you say you got 3 days from the day you received this notice, then all you have to confirm is that you sent it. And if you've got tracking on it, when that notice was delivered or attempted delivered, and then you start counting your 3 days. The date of delivery is day 0, doesn't count. 1, 2, 3 days after, on day 4 or after, you can proceed with your eviction. So by knowing how the count works, you're less likely to get turned around in court. By knowing what language in your notice kind of makes it a little wishy-washy, and avoiding that language, you're going to have a higher likelihood of success. And so, again, August 29th, we're going to have a workshop. I'm going to walk through all the notices: notice of termination, notice of default, notice to vacate, how to write them, how to send them, how best to use them in court. So if you're interested in that, again, there's a link. This is the paid. This is a paid workshop in the Houston area. If you would like to attend, feel free to check out more info about that in the link in the video description. So now, Ms. Holloway, I hope you are standing by because I've got your answer. Yes, you talked about a mechanic's lien for a car. This is part of her question. Tenant moved out, owes over $600. She left her vehicle in the garage, which we have no problem giving back to her. The car won't crank. She does not want to pay us the money owed. If we allow her to come and get the car towed, can we put a mechanic's lien on the car? We heard someone tell us that. Thank you. You probably can't put a mechanic's lien because you didn't do any work on the car. And so a mechanic or materialman's lien is appropriate when you service some piece of property or add value to some piece of property, and then by agreement of the other party, and then that other party says, I ain't paying you for it. So if a roofer puts a roof on your house and you had an agreement to pay X for the roof and you don't pay, they can put a mechanic or materialman's lien on your property to make you pay. In this case, you wouldn't need a mechanic's lien. You might already have a lien based on your lease. Dive into your lease and take a look at what it says. It might say your personal property on the premises serves as collateral or some kind of protection for which the landlord has a lien to secure payment of rent and fees and other things that are otherwise owed. Now, there's a complicated process of going through this, and you have to conduct a foreclosure, private sale, and so I don't know if this is exactly worth it to you. The mechanic's lien is not technically appropriate, but you could have a lien based on your lease. I don't know that I would recommend it. I don't know that it's necessarily worth it, but yes, it is possible. There are notice requirements that are required. You got to follow the rules in the code in order to be able to exercise these rights. Whether I would recommend it, or whether I would hire counsel to do it, again, now you're talking about additional expenses that really make it kind of cost prohibitive. So that's the bad news. But if the tenant is willing to pay the money, you can't really hold the car hostage, but you can get it towed. Chances are you can have the city come and just haul it away, and then they deal with it through the city. You don't have to store it on your property indefinitely. So if they're willing to come get it, I would say let them come and get it. If they say, well, I'll get there eventually, don't buy that. Call the city and see what the procedures are in your city for abandoned vehicles and getting them towed. The city may come by themselves, take it, and now the former tenant has to deal with the city. So that's a quick answer for you. Maybe not your favorite answer, but that's kind of the way it works. Let's see. DFW Second Chance says, thank you for discussing my questions. We recently hand delivered the notice. Is there a way to prove that in court? Well, kind of. You can take a witness with you, but I tell this story a lot, where we had a case where we were representing a client. Now, they hired us on appeal, and they served the notice to an individual by personal hand delivery, and they did have a witness. Now, they said, I extended it out, and the tenant took the notice. That was their testimony. When the tenant testified, she said, oh, no, they extended it to me, but I refused to take it. This was at the time of COVID. And she said, I didn't want to touch the paper they had in their hand, so I refused to take the notice. They put it on the ground and walked away. That was her testimony. My client insisted that he handed it to her and that she took it in her hand. She insisted I raised my hands like this and never touched the notice. The judge said the following. The judge says, listen, I find you, plaintiff, believable. I find you, defendant, equally believable. As such, the plaintiff loses because you have to be slightly more believable than the defendant. The proof level in a civil claim is by preponderance of the evidence, which means more likely than not. We call that 50 and a feather. So 50% and then just a tiny little bit more is more likely than not. If you can't meet that burden, if you are equal, you fail to meet that burden and you cannot win. And so, yeah, you can take a witness with you, but that's not definitive proof. Now, it is two people as opposed to one. And so maybe that's convincing, but this court didn't find it convincing. They said, you only have half proof. We're not buying it. And so you got to start over. It was depressing. DFW second chance. This is Kalisha Reed. Oh, great. Hi, Miss Reed. And so let's see. Ashley Holloway. Thank you. Okay, great. Will do. Well, that was all our time for today. Those are the questions that we had. Thank you, those of you who contributed questions on the chat. I will be back next week to join you live, August 20th. And the topic will be, can I install cameras on my rental property? The short answer is probably. I want to talk more in depth about that with you next week. I hope to join you live there. I hope to not have the same kind of technical issues I had and my better camera setup. But until next time, I hope you have a great rest of your week, landlords, and happy leasing. You're very welcome, guys. Always great to see you. James, Sherry, Alexander, take care.